Okay, on this video I thought I'd have a look at a question on the lines of how and why do pressure groups seek to influence the Supreme Court. Now first I'll have a look at the reasons why they try to influence the Supreme Court, and then have a look at some of the methods. So firstly, why? Well, I think the main reason why is that the Supreme Court has the power of judicial review, which means it can basically overturn any legislation or act by any other branch of government. And along with this, it's got the power to interpret the Constitution. And these powers have given it the power basically to make some very controversial decisions, very politically controversial decisions. So issues like, for example, campaign finance, healthcare, gun control, abortion, to name but a few, the Supreme Court has made decisions upon. The second main reason why the Supreme Court gains attention is that the people who are on it, there's 9 Supreme Court justices, are on there for life and are therefore influential over a very long period of time. So if you look, for example, John Paul Stevens was appointed by President Ford in the mid-1970s. He only retired in 2009. Currently on the court there are a few Reagan appointees still on the court, and people like Clarence Thomas were appointed by George Bush Senior, and people appointed by Clinton as well. So these people are on there for a long time, and with only being 9 of them, obviously they have a very influential position. Now the methods used by pressure groups, well, the first method is over the appointments, and it's to target the Senate and in particular the Senate Judiciary Committee in the confirmation process. Because remember, the confirmation process involves the President choosing a nominee of his choice. They then go before the Senate Judiciary Committee, who question the nominee, and they then have a vote as to whether or not they like the person. It then goes to the entire Senate, all 100 of them, who then vote, and if that person gets a majority, then they're appointed onto the Supreme Court. So one way which pressure groups can use to try and get the person they want on, or not on, is by targeting the Senate. And remember in class, for example, we had a look, didn't we, at the National Rifle Association. They ran TV adverts against the choice of Elena Kagan by President Obama, and they reminded people about Sonia Sotomayor, who said things like she favoured guns, etc., etc., and then the Supreme Court has voted to restrict guns. So they're trying to get adverts to get ordinary people to write to their senator to say, no, please don't support this particular person. Conservative groups were also unhappy with George W. Bush's choice of Harriet Miers in, I think it was 2004, and she subsequently stood down as a candidate after the number of pressure groups had lobbied the Senate and the executive over that choice. I suppose, thinking about it, another method they might use to try and affect the people appointed would be their support or otherwise of presidential candidates. So, pressure groups who supported Barack Obama to be president would obviously expect him to appoint a more liberal candidate, whereas groups who wanted conservative appointees would obviously have tried to get Mitt Romney elected. So there's actually the choice of president's quite important. A second method used by the court, used to influence the court, is by bringing test cases to the court. Now the most famous example, and it's also a really old example, so be careful in the exam, is the NAACP and Brown versus Board of Education. But we're going all the way back to the 1950s, so it's more of a historical one. You can use it in the exam, but I would also use a more recent example as well to show this. So you could use, for example, the Centre for Individual Rights, which is a pressure group. They provided funding for an affirmative action case, Grutter versus Bollinger, in 2003. And suppose Citizens United is also a pressure group, it's a conservative group. And of course we've got the whole Citizens United versus the FEC at the Supreme Court, so in 2010, so that could be a much more up-to-date example to use. The third method which groups use is to submit amicus curiae briefs. Amicus curiae means friends of the court, and this is basically when providing information for the justices. So Grutter versus Bollinger, there were 350 amicus curiae introduced to the court, and they actually did mention in the court judgment that they did help with their decision. There also had many amicus curiae briefings made in 2003 with Lawrence versus Texas, which struck down laws about discriminating against gays and lesbians, and Hamdi versus Rumsfeld in 2004. This was over Guantanamo Bay. That too had a number of amicus curiae briefs on that particular case. So pressure groups then have got 3 or 4 methods in how they try to influence the court, and they've also got a few particular reasons as to why they target the Supreme Court as an institution to produce their or to focus their activities upon.